marriage unit gave advice or support related to a possible forced marriage. And these figures almost certainly underestimate the extent of the problem, because in these fields many victims are unwilling to speak out. And forced marriage is clearly not just an abuse of immigration laws, but it's a breach of human rights. It's a form of violence against victims, and we're committed to tackling forced marriage. That's why we're defending the minimum marriage visa age of 21 against a legal challenge. We're still waiting for the Supreme Court's judgment on that, but we think having that minimum age of 21 gives young women, almost always women, a much better chance of taking their own decisions. And anyone who's convicted of domestic violence or have breached or the respondent of a forced marriage protection order will be banned from sponsoring an immigration application. They've demonstrated they are fit to be a sponsor as well. We have a duty to protect vulnerable people, and in 70 instances where the forced marriage unit gave advice in 2010 to people with disabilities, 50 of those had learning disabilities. So I'm proposing to our social services in England to carry out an assessment of an individual's capacity to consent to marriage when the sponsor is a person with learning difficulties or of another particularly vulnerable group. And I've asked the devolved administrations to consider similar arrangements in other parts of the country. So that's abuse of the system, but what we're consulting on is more than that. It's about promoting integration and social cohesion and ensuring people aren't a burden on the taxpayer, as I said. Now, we published a report, the second migrant journey analysis report, showing that on average, more than half of those migrants who come here for family reasons end up making the UK their permanent home. But that pattern varies enormously by nationality. Of the family migrants granted a visa in 2004, 86% of Bangladeshis and 81% of Pakistanis had settled here permanently by 2009, compared with only 10% of Australians and 11% of New Zealanders. Now, British citizens and those settled here are of course able to marry or enter into a civil partnership with whoever they choose, but it's reasonable to expect their spouse or partner to integrate into British society. And integration isn't something that happens overnight. It takes time to forge friendships and build bonds. So I'm proposing to extend the probationary period before a non-EEA spouse or partner can apply for settlement from 2 years to 5 years. This will allow additional time to integrate into British life and give us a longer period in which to test the genuineness of the relationship before permanent residence in the UK is granted. It will also make the route less attractive to those whose only purpose is to gain settlement here. Time and again, the border agency receives allegations from innocent men and women who have been duped into marrying a foreign spouse simply so that they can gain permanent residence in the UK. And extending this probationary period for non-EEA spouses and partners also reduces the burden on the taxpayer by millions of pounds by postponing access to non-contributory benefits like income support, income-based job seekers allowance and council tax benefits for that 3-year period. And as we move to a fairer, more consistent approach to all family migrants with a route to settlement, I'm proposing to end immediate settlement, definitely to enter, for adult dependents, including those aged 65 or over, and require them to complete a 5-year probationary period before they can apply for settlement. That's a big change, but it's right that we test all migrants' attachment to the UK, and the probationary period will also give time to develop the English language skills that are needed to live permanently and successfully in the UK. Because those English language skills are really important to making a success of living here. The benefits of learning English are widely recognised by academics and professionals, as well as by the migrants themselves who've improved their language skills and integrated into their new life here. Because most do that, but in contrast we see the consequences of people who are left isolated because they can't speak English, and who very often, just by that, create significant costs for the taxpayer. For example, in 2009-10, the Department for Work and Pensions spent £2.6 million on telephone interpreting services and another £400,000 on document translation. That's just one government department. Comparable costs are borne across the public sector, both by central government and by local government. We want to encourage integration, and that is clearly helped by a sufficient capacity to communicate in English. And this is particularly important where migrant communities continue to favour marriage to a spouse from overseas rather than to a British citizen or a person already settled here. That's why last November we introduced a requirement for those applying for a visa or leave to remain as a spouse or partner to demonstrate a basic standard of English. And we propose to extend this requirement to dependents aged 16 and 17 and to adult dependents aged under 65. And building on that existing English language requirement, we propose to require adult family migrants aged under 65 applying for settlement to be able to demonstrate that they can understand everyday English. 71% of those granted settlement as a spouse in 2009 and 2010 already met that everyday English level, B1 in jargon, by passing the Life in the UK test. We think it's right that the remaining 29% and adult dependents aged under 65 should have to demonstrate the same standard. And interestingly, the consultation's been running for a couple of months now, and most of those who responded agree with this approach. Family migrants also mustn't be a burden on the taxpayer. They must have access to enough money to support themselves and to participate in everyday life, using local shops, local services, as a basis for integration. Our analysis of just over 500 case files from 2009 found that around 20% of sponsors were either unemployed or had an income below the national minimum wage, and only 28% of the applicants reported being in paid employment at the point of their application. We also uncovered a number of sponsors who claimed to have adequate accommodation to support their spouse and dependents, but at the same time were claiming to be homeless and accessing social housing from their local authority. In one specific case, a sponsor submitted evidence of his self-employed earnings, but a check with HMRC showed that he declared a different income and owed £5,000 in unpaid tax. So we're sending out a clear message: if you can't support your foreign spouse or partner, you can't expect the taxpayer to do it for you. The current maintenance threshold, which is equivalent to the level of income support, isn't enough to provide adequate maintenance. Income support is a safety net for those who've fallen on hard times. Its level doesn't provide an adequate basis for integration. I therefore ask the Independent Migration Advisory Committee to advise on what a new minimum income threshold should be, so that family migrants are supported at a reasonable level that ensures they don't become a burden on the taxpayer and allows sufficient participation in everyday life to facilitate integration. And in applying a minimum income threshold, we'll review whether support from third parties, which is not easy for the UK Border Agency to verify, should be allowed, and if so, in compelling and compassionate circumstances. So apart from money, I want to ensure also that sponsors have adequate housing that's not provided at the expense of the taxpayer and is not overcrowded. 37% of sponsors from that sample of just over 500 case files said they were living with family or friends. So in the future, if you can't provide a mortgage or tenancy agreement, you may be expected to ask your local authority to verify that your housing is adequate and not overcrowded. So the proposals in this family consultation will ease pressures on housing, on public services and on local communities, and through that will help strengthen social cohesion. There are other areas we are consulting on which are hugely important to the integrity of the immigration system. We're consulting on family visit visas. These are huge volume of these. In 2010 we processed almost 433,000 applications, 73% which were granted on initial decision. And obviously these are very important, but we have some concerns about how the system operates. No other category of temporary entry clearance carries